Niva, Elkin-Koren, is a professor of law at Tel Aviv University, Faculty of Law, and is a leading scholar of fair use law, both in the United States and in her home country of Israel, and was there and participated in the debates around the adoption of a fair use standard in Israel, which is a relatively recent change in Israel's law, but old enough to have been studied by her, including in the case law that's been adopted under fair use law. Let's turn to Niva and a case study of Israel and that one country's particular experience with adopting and then implementing and applying its fair use clause. Niva, over to you.
It's great to be here. I'd like to actually use this fantastic broad view that Peter has presented to us. Israel actually started with a spectrum that Peter just described to us between fair dealing and fair use. So we used to have a 1911 Copyright Act that we inherited from the British Mandate over Palestine, and with the copyright law until 2007. And that was actually a fair dealing provision that required the court to sort of first consider the purpose of use according to a closed list of enumerated uses, and then to consider the fairness of use. The new law moved away from this, introducing an open list, allowing the court to consider uses such as the uses that are enumerated by the law, and also added a few additional purposes of use that could legitimately be considered fair use, such as a use for instruction and examination by educational institutions, quotations that we didn't have in the old law. At the same time, also requiring courts to consider the fairness of use. I emphasize that because what the new law actually maintained was the two-pronged structure, but at the same time, created high hopes for this shift from fair dealing that is more narrow into a more flexible norm that would enable, for instance, the making available of materials for educational purposes, for research purposes in the broad sense, but especially in the technological context where we have a vibrant high-tech sector that need to adjust copyright uses to ongoing changes in technology. The fair use provisions were perceived as the great hope for introducing some flexibility. What we see here is that the provision that was introduced under the new Israeli law was almost a complete copy of the American provisions, except for very minor changes, one of which was actually highlighted by Peter before, and that is the discretion that was given to the Minister of Justice to make regulations that would provide some certainty and would list some uses that would be explicitly permitted according to Section 19, thereby bridging the gap between the need to introduce more flexibility and at the same time maintain some certainty for some players that cannot cope with the high risk and the high costs that come with it, where it is unclear what is the scope and limits that apply to permissible uses. And so we heard much about legal transplants on the side of the advantages and the benefits, and also on the side of the costs and the risks that are associated with legal transplantation. But let me just add a few concerns to the ones that were listed by Peter. And that is the concern that when you transplant a legal rule or a legal concept from one legal system into the other, this superficial transplantation may cut off the legal tradition that was developed in one place and will not make this type of tradition accessible and available to courts and regulators that need to implement it in another country, and thereby cutting them off from a tradition that could set the ground for developing proper definitions and jurisprudence related to the interpretation of these concepts and rules. Consequently, one of the major concerns related to legal transplant is that it may create what is sometimes described in the literature as a jurisprudential chaos or some inconsistency that may defy the legislative purpose and overall would lead to some unintended consequences. Some of these concerns were actually raised by the very vibrant opposition to the introduction of fair use exemption under Israeli law, especially by American industry. Let's take a look at some of the arguments made by the opposition. So one concern was that unlike the US that has developed many years of jurisprudence and case law, in the context of fair use, judicial authorities in Israel lack that capacity and therefore may lead into broad and expensive interpretation of fair use provisions that would actually be a free ticket to copy copyrighted materials. A second concern was that Israel may be in violation of its international obligations by implementing a fair use provision, and therefore it has to incorporate the TRIPS three-part test into the fair use clause. That was, of course, a weaker claim on behalf of the American industry, just because you don't have any similar equivalent in the American statute. A third concern that was raised by the industry was that the statute itself actually lacked an important reference to the commercial nature of the use as one of the considerations that has to be taken by the court, and the concern was that, again, this would lead to some broad interpretation on behalf of the court. With that shift to fair use in Israel, was it all a legal transplant? One may question that, and the reason is that the shift to fair use was implemented way before the legislations of 2007 in a ruling of the Israeli Supreme Court in a lawsuit that was brought against Dudu Geva, a famous Israeli comic artist that published a book called the Duck Book, in a lawsuit that was brought against him by Disney, claiming the copyright infringement in Donald Duck. Geva claimed fair dealing. That was in the beginning of the 90s. And the court had to consider whether the purpose of use and the fairness of use qualify as fair dealing. For the purpose of use, the court actually was willing to broadly define criticism as one that would apply to this particular use that you can see in the drawing on the slide, broadly defining criticism as any way in which a user put the original work in a different context or in a different light that provides it with a new meaning. This is a very broad and expansive interpretation of the purpose of use for criticism. The problem was with the fairness of use, and here the court looked around and said, this is a legal standard for which we don't have any systematic way of analyzing this requirement in the law, and therefore actually imported into the Israeli copyright jurisprudence the 4 factors that are listed under the 1976 US Copyright Act. So the 4 factors were in fact applied by the Supreme Court in Israel in 1993, and thereafter were actually incorporated into the analysis of the lower courts even before 2007 with the new law. So what I would argue is that in fact fair use in Israel was not really a transplant, or it was not a full transplant, but actually codifying fair use that was sort of introduced into the case law in the old traditional common law way. And so the question is whether this has made a difference. And in order to study this, Neil Netanel from UCLA and I actually conducted an empirical study of a decade of case law over 10 years, and compared fair use analysis in Israel after the introduction of the fair use provision, comparing it to the situation in the United States. Overall, you can see that we have studied in Israel 55 reported cases, out of which 4 were Supreme Court rulings. In the US, we had a corpus of 185 reported rulings, 157 were district court cases, 28 appellate court cases, and none US Supreme Court cases during that 10 years period. And so the question is whether the concerns regarding this transplant of fair use provision, that it will introduce some sort of a free ticket to copy, were right. And our findings actually show that Israeli courts over the first 10 years of implementing the fair use provision were pretty conservative, at least compared to US courts. So if US courts reached a finding of fair use in almost 50% of the cases, in Israel it was less than 30% of the cases. Of course, one has to take into account the fact that in some, the cases might be different. There are different incentives for plaintiffs to bring lawsuits in different jurisdictions, and that depends on legal procedure, that depends on remedies. But I think that overall, the differences are quite striking. Another concern that we have seen was related to the lack of consideration of commercial use. And just to highlight this, in the original US Copyright Act, from which the Israeli provision was actually copied, you can see that the first factor includes some provisions guiding the court to consider whether the use is of commercial nature or is for nonprofit educational purpose. As you can see in the Israeli provision, this type of guidance is lacking. And one of the concerns raised by the American industry opposing the statute was that this would lead to overlooking the importance of commercial nature in weighing against fair use. And again, our findings actually show the opposite. When the use of the work by defendant is commercial use, American courts find fair use about 50% of the cases, whereas Israeli courts only found fair use in 10% of the cases where the defendant was a commercial player making commercial use. Nevertheless, the courts also in Israel did announce in a lot of the reasonings that commercial use is not the only factor to be considered, which brings me to my last point related to this shift to fair use in comparison, and the last concern that was raised by the opposing industry, and that is that introducing fair use provision would lead to jurisprudential chaos, and that the local courts will simply not be able to handle it. What is really interesting in the findings is that Israeli courts were pretty independent. In fact, the concern that it would be difficult to develop a local norm of fair use was shared also by the Israeli Ministry of Justice. And therefore, when they introduced the copyright bill, they explicitly mentioned that the reason for copying almost identical language from the American statute was in order to, as Peter Yu said, free ride on the type of the case law that has already developed in the United States and enabled the courts and litigants to rely on these cases. Nevertheless, as you can see, Israeli courts were reluctant to actually cite American case law or the American fair use statutory provisions. That is on one hand. On the other hand, the two Supreme Court rulings did cite American decisions, and one can actually see that some of these decisions, especially Sony and Harper and Rowe, were very influential on shaping Supreme Court cases. Even the case of Geva that I've just mentioned before, that was actually a case before the law. Another issue or difference is the way in which the two-pronged structure of the Israeli fair use was actually sustained by the Israeli courts. And so the question is whether there is any link between the enumerated use or legitimate uses that are actually explicitly mentioned in the US fair use preamble. In the US, we found no statistically significant connection between the finding of fair use and these enumerated uses, whereas in Israel, actually 90% of the rulings, the courts were actually looking at these enumerated uses, this time not looking for a particular use that will be explicitly listed by the law, but at least looking to find some connection to uses that are used, such as the type of legitimate uses that are listed explicitly by the law. And you can see that here the courts were actually sustaining the way in which the legislator have shifted. And again, here I agree with Peter in an evolutionary way from fair dealing to fair use, creating a norm that is more flexible, but not creating a whole new paradigm. On the issue of transformative use, as you may have heard in some of the other meetings, this is the key for finding fair use in the United States. According to all empirical studies that have been done on fair use, it's the most important predictor for a fair use finding in any particular case. And this was consistent also in our own study. 97% of the ruling explicitly addressed transformative use, and this was in direct link to the finding of fair use. In the Israeli case law, transformative use was mentioned only in 8 rulings, but in the 2 Supreme Court rulings, transformative use played an important role. Again, these are more significant cases that are affecting the development of the norm. And more importantly, recently, like just before COVID, but right after we finished our empirical study, so the 10 years period, there was an important Supreme Court decision, the Intl decision, that was held in August 2019, where the court expressly embraced the transformative use approach that was enunciated in Campbell. And therefore, if we need to predict about the 10 forthcoming years, it looks like transformative use may play a more important role in Israeli case law. 2 more points on the Israeli local bottom-up self-created jurisprudence. One is that an additional condition was actually self-developed by lower courts, and that is the requirement that a credit will be given by the defendant to the plaintiff as a condition for the recognition of fair use. That is a very problematic requirement. Supreme Court in the case that I've just mentioned, in the Intl case, actually relate to that and criticize this. But that just shows that Israeli courts felt at liberty to actually develop a norm that may make a lot of sense in terms of the equity that it reflects, but nevertheless inconsistent with American case law, and thereby actually also narrowing down the scope of fair use as applied in Israel. I think the most significant contribution of the legislation of fair use in Israel was that it introduced a new way for courts to conceptualize the framework of fair use. So whereas the court in the 90s imported the 4-factor analysis as is, the court in the recent decision of Intl in 2019 actually looked at fair use as reflecting a deeper commitment to the underlying purposes of copyright law, that is to enrich the public domain with creative works. Therefore, the court actually introduced a new way to classify the 4 factors analysis, under which courts are actually invited to consider 3 questions. Does the infringing work promote socially valuable objectives, such as encouraging the creation of new works? The transformative test, by the way, could be listed under that. Does the use impair the incentives of the original author? The 4th factor could be listed here. And I think most importantly, another standard that is not fair use, but is very consistent with Israeli jurisprudence, and also European, by the way, that is proportionality, the extent to which the actual use is necessary for enabling the legitimate purpose for which it was made, either research or education or technological development or anything of that type. So to conclude, does fair use matter? We've seen that local courts were pretty conservative compared to American courts, and actually did not deliver, so to speak, on the high hopes that were linked to fair use when fair use provisions were legislated. At the same time, I would say that legal reforms take time. And I think that one of the indications is the 2019 Supreme Court important decision that is actually taking fair use a step further. I also think that Israeli jurisprudence is developing fair use in a creative and original way that could take fair use actually forward. Sometimes the four factors analysis that was actually simply developed by American courts prior to the 1976 law. Actually, these four factors don't make much sense. And if you look at the purpose of fair use and not necessarily stick to these four factors, you may come up with better trade-offs. Another important issue to bear in mind every time we look at empirical studies that are looking only at case law is that we can't measure legal changes only by rulings and court decisions. We have to look at behavior and law in action. So a lot of the things that have to be measured in order to truly understand whether fair use made sense and made a difference compared to the situation before the enactment of the new statutory fair use provision. What we need to do is to actually look at actual behavior. And in this context, it's important to mention that, for instance, academic institutions in Israel developed fair use best practices based on the law that so far have become the basis for the use, more liberal use of educational materials, both in high education institutions, but also in the general education system. So the provisions have definitely made a difference in the behavior that did not make it into the court. And finally, on the local conclusions, it looks like the introduction of fair use provisions also helped both practitioners and the court to articulate permissible uses, not as exceptions, but rather as user rights. We still don't have a final ruling on this, but definitely courts are considering this. 2 seconds on some insights on the global debate. Since this really belligerent opposition of US industry in Israel made some strong statements against fair use, I think one of the lessons is that this type of opposition by right holders industry should be taken with a grain of salt. We really need to have evidence-based discussion before we run into conclusion and speculations about some imaginary risks related to more flexible norms. Thank you.
That was fantastic. Thank you both very much.